The UK Supreme Court has finished hearing the arguments of the parties in the dispute between Russia and Ukraine on Eurobonds in the amount of $3 billion, which is also called duty of Yanukovych. Everything will depend on the verdict of the five lords at the Supreme Court, a decision they will announce within a few months, maybe in the spring, but probably summer. Before Bromidem 2013, Moscow loaned Kiev $3 billion. She believes the transaction is commercial and asks the court to oblige Ukraine to return the money. Kiev refuses, as I am sure that Vladimir Putin's threats and pressure imposed credit. Viktor Yanukovych soon fled to Russia. Thus, Ukraine has received the right to sue Russia, in fact, to prove the pressure, to call witnesses, to blame the Kremlin for the annexation of Crimea and armed intervention in the Donbas. Russia, which denies pressure and military intervention, appealed against the appeal to the Supreme Court. She requests the accelerated process, which will consider only one question: paid or not Ukraine. If the Supreme Court will benefit Russia, and the Commercial Court will decide in its favor, Moscow will be able to start hunting for Ukrainian assets abroad, or to put Kiev to the negotiating table. So far, Ukraine has refused to discuss the restructuring of the $3 billion of organosilika since Russia recognized as an aggressor, and the duty received by the former president before the Revolution of Dignity, in which he fled to the debtor. If the trial in the British High Court will benefit Ukraine, a new process in the High Court of England promises her an international platform for accusations of Russian aggression and pressure. The Supreme Court hears only cases that have a constitutional significance for the whole of Britain. His task in this case is not to judge the dispute of Russia and Ukraine, and to define the role and powers of the English courts in it. It is the duty of Yanukovych have been issued bonds issued for English law. Disputes concerning such debt is commonplace for the English courts, but traditionally they are companies and banks. With the country's situation is more complicated, because the courts do not interfere in international relations. The Ukrainian side is trying to prove that corporate law in this case can be applied when examining allegations of coercion to the agreement, despite the fact that the agent of coercion is the state, and not a commercial venture.